Ohio's Open Meetings Act mandates that a public body conduct its official business in open meetings. But what counts as a public body? A public body is different from the public offices that are required to comply with Ohio's Public Records Act. Not all public offices are public bodies, although most public bodies are also public offices. A public body is any board, commission, committee, council, or similar decision-making body of a state agency or legislative or other decision-making body of a county, township, municipal corporation, school district, or other political subdivision or local public institution. The Open Meetings Act provides that not only the primary public bodies, such as a city council, but also the committees or subcommittees of the primary public body are all public bodies subject to the obligations of the Act. Examples of public bodies include township boards of trustees, county commissions, the board of directors of a county agricultural society, as well as a temporary selection committee created by a state agency. Open Meetings Act states that it does not apply to the General Assembly, grand juries, the Ohio Organized Crime Investigations Commission, Jobs Ohio, and any committees of Jobs Ohio and other agencies exempted by statute. A public body needs to meet the Open Meetings Act requirements when it's a prearranged gathering of a majority of the members of the public body for the purpose of discussing or conducting public business. The third part of the definition is the trickiest. Some courts have found that a presentation by a third party to a public body where there is no deliberation of the public body's official business among the members is not a meeting. However, a work session or retreat where public business is discussed meets all three criteria and is a meeting, regardless of what it's called. The Open Meetings Act requires that any time a meeting is planned, a public body must give notice of the meeting, conduct their business openly, and take and publish meeting minutes. The Open Meetings Act requires that a public body establish its own rules of how it will provide reasonable notice of its meetings. For regular meetings, those rules are required to allow the public to determine the time and place of regular meetings. For special meetings, the rules established by the public body must additionally allow the public to determine the time, place, and purpose of the special meeting and give at least 24 hours notice to all media that have requested notification. The notice of purpose of the special meeting must specifically identify the topic or topics that will be discussed. Only topics identified in the notice of a special meeting may be discussed at that meeting. The only exception to this 24 hours notice is an emergency meeting, which is a special meeting where circumstances require the body to take immediate official action. For an emergency meeting, the public body must immediately notify all news media that requested such notice of the time, place, and purpose of the emergency meeting. With regard to openness, the Open Meetings Act requires that a public body conduct all deliberations on official business in meetings open to the public, unless otherwise specifically provided by law. This means that a public body cannot vote by any form of secret ballot. The public body may not evade the openness requirement by having less than a majority of members discuss the same piece of official business in round-robin or serial meetings. The Open Meetings Act allows a public body to go into an executive session from which the public may be excluded to discuss and deliberate certain matters in private. The Act permits executive session only for specified limited topics. While in executive session, the public body may not make formal decisions or vote. Any resolution, rule, or formal action of any kind is invalid unless it is initially adopted in an open session of a meeting where the public may observe the decision being made. The Open Meetings Act requires that a public body keep full and accurate minutes of all meetings and make those minutes available to the public for inspection. The meetings do not need to be a verbatim transcription of what happened in the meeting, but must provide enough information so that the public can understand the rationale behind the public body's decisions.